Hi, my name is Samaria Dunson, and I'm the Director of the Office of Compliance and Ethics here at the Alabama Department of Public Health. I'm here to talk to you about business associate agreements. What are they, and when should we use them? Now, if you're watching this training, that means that you have access to the contracts database. And if you have access to that system, then that means that you're a decision maker about whether or not a business associate agreement should be used. So some of the topics that I'd like to discuss with you are understanding who may be considered a business associate, why business associate agreements are necessary, and understanding the exceptions. Now, when we talk about protected health information, let's remind ourselves about what actually qualifies as protected health information. So there'll be examples like that you see on the slide. Their name, address, the obvious ones, date of birth, a date of service, that may be an identifier that we tend to forget about, social security numbers, diagnosis, telephone numbers, and emails. But what we also want to consider is that there are other forms of protected health information, like full-face photographs or other comparable images. Medical record numbers. This would include not only an ADPH record number, but a Medicaid record number, and any other information that an individual will be able to use to identify a patient or a client. And when we're talking about protected health information, we want to remember that there are a couple of exclusions. Those exclusions include employment records. So for instance, here at the Department of Public Health, we may be providing information on our employees to send to the retirement systems of Alabama or to PHIP. And in doing that, that would not be considered protected health information because they're not our patients or our clients. They are our employees. So that's an exclusion. And then also education records would also be considered an exclusion. So what is a business associate? A business associate is a person or entity that creates, receives, maintains, or transmits protected health information on behalf of the department. Now, some examples of business associate agreements appear on the screen, and I'll go into each of them a little bit. The first are shredding companies. We've identified them as a business associate. Part of the reason for that is we're providing them with protected health information when we put those medical records in those bins that Gilmore or other services pick up. When we put the protected health information in those bins, they are receiving our protected health information in order to do something on our behalf, which is to shred the information. So we wanted to make sure that we had business associate agreements in place with them, because if they take those bins and misplace them or lose them before they shred the documents, or if they take them and there's an accident on Interstate 85, and so therefore the records are going everywhere. Well, we want a BAA in place with them so that it's not our responsibility for that breach. Once it's in their hands, it's their responsibility. Another example is going to be the companies that we have leased copiers with. I know a number of you have identified that we have hard drives within a number of our copiers. This can be an issue because those machines are actually saving for a short period of time. They're saving those copies that are going through, which can have protected health information on them. One way that this comes into play is that if you have someone who's coming to service that copier, they could actually print off the last several jobs and see protected health information. Or when our lease is over with that copying company and they take the machine, the procedure is supposed to be that they wipe that hard drive clean before they leave. But in case they don't do that correctly or they don't do it at all before it leaves the department, we have a business associate agreement in place with those copier companies to say, once that machine leaves ADPH property, you're responsible for the PHI that's on that machine. Another example is going to be our software companies that remote into our computers to troubleshoot. And I can further explain that in our legal office as well as the Office of Compliance and Ethics. An example is going to be that we have a program called Time Matters, and that's something that we use to put all of our cases in. And we actually have, from time to time, protected health information that's associated with a case or associated with an investigation. Well, there have been times in the past where for some reason that software wasn't working, or that database wasn't working. And we had to contact tech support at Time Matters, which is a LexisNexis product, and actually have them remote into our computer so that they can troubleshoot and fix that problem. Well, we have a business associate agreement with them because they have the ability to access information while they're doing something on our behalf, which is troubleshooting. And then the final example that we have on the sheet are companies that perform mass mail-outs of protected health information of our patients. And I wanted to explain that a little bit further as well. When I say mass mail-outs, I don't mean UPS, FedEx, the United States Postal Service. What I mean is a contract that we will have with a vendor or a company where they will actually physically put the paper in the envelopes to mail out. Well, there is certainly the possibility, and there have been instances in the past, not very many, but instances where, because of the way that they have it set up, if they're doing 400 mail outs, if they start getting one letter off, like maybe 2 pages get stuck together and that goes in the envelope, so all of the remaining ones are off, there's the potential to have a very large breach, because all of the ones that happen after that mistake will be me getting somebody else's protected health information. So whenever we have a contract or an agreement with someone to do a mass mail out and it has protected health information of a patient or a client, we want to make sure that we have a business associate agreement in place so that that company is responsible for any breaches that they create and the Department of Public Health is not. So after that, I want to talk with you a little bit about what are some of the terms of a business associate agreement. I actually have a copy of a business associate agreement here. It's a 8-page document in terms of the substance of the document, and I will not attempt to read that to you. In the legal world, it's actually a pretty short document, but I did want to go over the next slide to show you some terms that are very important. One of those things are the uses and disclosures of PHI. It actually spells out how each party will use and disclose that information. It talks about the obligations of the business associate to safeguard the PHI. They have to have certain things in place to make sure that they have training and that they're not leaving that information out so that it remains confidential. They also, these agreements also spell out how breaches are going to be handled. So for instance, it'll say if a particular business associate becomes aware of a breach, they have to let us know at the department within a 5-day period and that type of thing. So how those breaches are handled are very important. And then finally, how PHI will be handled when the relationship is terminated. And I want to explain that part a little bit further, because let's say you have a contract with a group and you have a BAA associated with it and you're giving them PHI. Well, if that contract ends in January of 2016, that group still has the protected health information of your patients. So these business associate agreements spell out, hey, in January 2016, when this relationship is over, either you have to give us back all of our PHI, or if that's not feasible to do, you need to make sure that you destroy it or that it's safeguarded, that you keep it safe so that there won't be any inappropriate disclosures that are made. So I wanted to just review with you those terms. Now, when considering whether a business associate agreement is necessary, I want you to ask yourself a couple of questions when you're sitting down at your computer in the ACES database. The first question that I want you to ask is, do you understand the relationship between the parties? Because if you don't understand the relationship between ADPH and this person or this group that we're about to provide information to, then you're not in a situation where you can determine whether or not a business associate relationship exists. So you want to make sure that you understand the relationship. The second thing I want you to make sure of is that there's actually an exchange of PHI between the parties. And more specifically, is ADPH giving our patient information? If we're receiving somebody else's protected health information, we're not in a position to provide them with our BAA. But if we're providing PHI to that other party, we need to make sure that we are considering having a BAA. If there is not an exchange of PHI, you don't need to worry about a business associate agreement. And then finally, in sharing our PHI with the other party, will that other party be providing a service on our behalf? And what I mean by that is this. There are certain instances in the department where just because we're required to, or because they're required to by law, they have to provide us with information. An example of that would be our immunization database. By law, there are certain groups of people or entities that have to provide us information for that database. And then also by law, we need to share that information with other people. In that relationship, they're not doing anything on our behalf, and we're not doing anything on anybody's behalf. Everybody's just sharing information because they're legally required to do so. In those instances, you won't need a business associate agreement. You may need something else like a data sharing agreement or a trading partner agreement, which I'm happy to talk with you about and help you get those agreements ready. But in terms of a business associate agreement, they either need to be creating, maintaining, or receiving our protected health information and doing a service on our behalf after they get that protected health information. The next slide shows a flowchart. Now, this flowchart was a part of the 2013 HIPAA policy. It was a part of the 2014 HIPAA policy when it was amended, and I feel very certain that it's going to be a part of the HIPAA policy that goes out this year. I think that this is a very good flow chart. I've not had any issues with it in the past, but if I may, I just wanted to go over a couple of things on that flow chart with you. You'll see in the right bottom corner that there are already exceptions. So when you're looking at the database, you're trying to decide if there needs to be a business associate agreement, I want you to review those exceptions first to make sure, hey, this is de-identified information, so I know I don't need to do that. This is from a postal service or some type of mail carrier like FedEx or UPS, because those you don't have to have business associate agreements with them. I just want you to pay attention to that. Also, looking at this flow chart, on the very left-hand column at the bottom, there's a red box that says a business associate agreement is required. Well, right above that, there in that black box right above it, it talks about the treatment, payment, and healthcare operations exception. And I want to go this very next slide. I want to talk with you about that. Whenever you're trying to decide whether or not a business associate agreement exists, in addition to the exceptions that are listed on the flow chart on the right side, you also wanted to pay attention to that box that I was just talking about. So on this slide, you'll see where there are treatment, payment, healthcare operations exceptions. So if you're providing information to a doctor's office for continuity of care, you're serving the same patient, no BAA for that. If you have a relationship with Medicaid because they're paying for specific services or Blue Cross Blue Shield, you don't need any BAAs for that, or if it's for healthcare operations. There are a couple of others on this slide that I do want to note because they have come up from time to time, and those are janitorial services. We do have certain areas within our department where janitors come in after hours. Our policy is that our protected health information needs to be secured at the end of the day. So janitors should not be accessing or have the ability to access our patient or client's protected health information while they're doing their duties in your area, in your county, in your office. There are certain offices, and they've already gotten permission to use daytime housekeeping because of the way that they're laid out. It's very difficult for them to make sure that that information is secure. They have swipe access, that type thing, and those janitors come during the daytime so that there's an employee to constantly watch and monitor them. And so when they leave at 5 o'clock, there shouldn't be anybody that's unauthorized in their unit. But as far as the janitorial services go, what we do require is that we are now requiring that they sign a confidentiality agreement saying that they know that the Department of Public Health has protected health information. They know that if they view and wrongfully disclose that information, that is a criminal and civil sanction associated with that, and that they agree to keep that information confidential. So as it relates to the janitorial services, they would be an exception. As we discussed a second ago, U.S. Postal Services, FedEx, UPS, anybody that's acting as a carrier for sealed envelopes, with protected health information in it, you don't need to consider doing a business associate agreement with them. And then finally, we have the interns and the volunteers. Now, this has come up too. What I want to make sure that we understand as a department is that we need to be very careful with who we decide can be an intern or a volunteer for us. And the reason for that is when we take on an intern or a volunteer, we actually accept them as members of our workforce. So just like other employees are able to access certain things and you don't have a business associate agreement with those employees, because interns and volunteers are members of our workforce, we won't have business associate agreements with them either. So if you are looking at entering a contract to UAB for some nursing students that are going to be coming down, and they're going to be interning in one of our county health departments for a day, for a week, for a month, for a semester, we're not going to be getting business associate agreements with them because they're going to be accepted as members of our workforce. We also, before this training, or as we were thinking about preparing for this training, I sent out an email to a number of you who, well, actually to everybody who at that time had access to the contracts database, because we wanted to gauge the pulse of what types of questions do you really have? And we were lucky, we did get some responses. So I want to go over just a few of those questions with you very quickly. One of the questions was, if you are renewing a contract with the exact same verbiage as last year, and you are required to have are you required to have a new approval letter to go along with the business associate agreement? And she says the only thing changing is the effective date and the expiration date of the contract and the BAA. So any of you who have gone through the ACES database, the contracts database, and gone to the BAA section, you'll notice that there's a cover letter. The reason for there being a cover letter for me to sign is that when you're initiating, at the very beginning, when you decide a business associate agreement is necessary, if you were to provide that cover letter to me, that allows me to know, hey, there's somebody contemplating a business associate agreement, and it allows me to have a conversation with that person to make sure that there's a business associate agreement, that there's a business associate relationship. Because what we don't want to happen is that we just send out mass amounts of business associate agreements that are not appropriate, and then it's a bad reflection on the department. It looks like we don't understand when a business associate agreement is necessary or when it's not. So initially, if you're about to engage in a contract and you think that a business associate agreement is necessary, I do want you to at least contact me so that I understand the relationship and I'm helping you think through that process. Now, for this question, this is just a renewal of a contract and a BAA that's already in place. So both parties already understand that there's a necessity for a business associate agreement. In those circumstances, you don't need to worry about providing another cover letter and sending it to me. You can provide them the business associate agreement in the same packet that you provide them with the contract. And so you don't need to worry about that. Another question that we had is whether or not a business associate agreement can stand alone, or does it always have to be associated with a contract? Yes, you can have a standalone business associate agreement. I would say 95% of the time they're going to be associated with a contract. But an example would be if you buy an off-the-shelf product, like some type of software, and so you don't have a contract. Like an example that I used about Time Matters, which is the software that the Office of Compliance and Ethics uses and the Office of General Counsel. Well, we have that product. We may have a maintenance agreement, but we don't have an ongoing contract about that product. But we have a business associate agreement with them. So whenever you see where you're utilizing a product and they're able to receive, maintain, and access protected health information to do something on your behalf, like with that example, it was troubleshooting for us when we had issues with it, you want to make sure you have a business associate agreement. So yes, they can stand alone. The final question that we had to do with the HIPAA clauses that were in the contracts versus a business associate agreement. So let me tell you why we have to have both. For many of you all that have been around for several years, you will remember that with our contracts, we used to have 5 pages worth of HIPAA clauses. And you now notice that in the last 2 years, those 5 pages have been reduced to 2 paragraphs. And the 2 paragraphs that are in all of our contracts now just state that, hey, I recognize that there may be an exchange of protected health information, and I agree to follow the HIPAA regulations. But that's pretty much all those HIPAA clauses say. So when there is a need for more, how you're going to disclose it, when you're going to disclose it, when the relationship terminates, how you're going to handle a breach, All of those things are related to the business associate agreement. And so that's why you need to have both. And maybe even more important than that, in 2013, when the federal regulations changed, they required us to have business associate agreements in place with entities or individuals that were considered to be business associates of the department. So it's actually a federal regulation that we have these business associate agreements or BAAs in place. And those were all of the questions that we have. I would encourage you that if after watching this training or over time you find that you have additional questions, there's a slide associated with this training that has my contact information on it. I'd love to hear from you. I think that a number of people who contact our office will note that we try to get back with people as soon as we can, generally the same day or the next day. I love this stuff, so I'm glad to answer these questions. And what I want to make sure that you understand is we're not trying to make you into HIPAA experts. We only want you to be an expert at your job, but we want to make sure that you have the information that you need to make appropriate decisions while you do your job. So like I said, after this training, if you continue to have questions or if there are gray areas that may not have been covered in this training, please contact me and let me know, and I'll be glad to help you. So thank you for tuning in and watching, and I look forward to hearing any questions that you might have in the future.